All right. Hello, everybody, and welcome. My name is Bianca Beck. I am the Middle East and Mauritius Marketing Manager for Sovereign PPG Corporate Services here in the Middle East. Thank you so much for joining us today. We're really excited to have you with us to explore the topic of moving to the UAE. So this is a practical guide for UK and UK tax considerations for international families. We are especially pleased to be joined by our speakers. So firstly, we have Oksana Sukhar, who is our Senior Business Development Manager at Sovereign PPG Corporate Services with me here in the Middle East. She has extensive experience in international structuring, private wealth planning, and global mobility for clients all across the world. Joining her today is the team from Irwin Mitchell in the UK. So we've got Yousafa Hazara, who is the partner of International Private Clients Services at Irwin Mitchell. Yousafa has specialized in cross-border wealth planning, international tax, trusts, and succession planning for high net worth individuals and their families. And also alongside her is Jessica Fazzone, who is the legal director, again, at Irwin Mitchell. She advises clients on international tax, estate planning, and cross-border structuring solutions. So yeah, enjoy today's session. We really encourage you to participate as much as possible. So please submit any questions you might have through the Q&A section. And we will do our best to address as many as possible towards the end. And then other housekeeping rules, the session is being recorded and the presentation and recording will be shared with you afterwards. So yeah, interact with the team. We've got some great speakers today. And without further ado, I'll hand over to Yousafa.
Thank you so much, Bianca. Good morning or good afternoon, everyone, depending on where you are. And thank you so much for joining us today. Hopefully, as Bianca said, this session will be really interactive. So please do put some questions in. And the whole point of this webinar is to help you, whether you're leaving the UK yourself to move to the UAE or whether you're an advisor helping clients move to the UAE. We have a lot to get through in this 1 hour session. And again, as I said, please be interactive because I don't want to be the only one asking questions. As most of you know, there has been a lot of geopolitical uncertainty recent times in the Middle East, but that hasn't stopped clients from leaving the UK for the Middle East, whether that's temporarily or on a permanent basis. So from Jess and I's experience, my colleague Jessica, who's one of our panelists, we're seeing a lot of people looking to move to the UAE. The political situation and the uncertainty hasn't helped. In the UK, as you know, we're going through crisis at the moment with our government. So I can only imagine that we'll be sending more people out of the UK, which is slightly sad, but I guess good news for anyone who's waiting at the other end to welcome some of our clients or people that are leaving. And just one point to make before we get into the panel discussion, when we're thinking about people that are moving to the UAE, we're not talking about the ultra high net worth or super high net worth. This could be anyone who's looking to move. So even professionals, lawyers, doctors, engineers, expats, anyone. So hopefully this will resonate with most of you. So let's get the discussion going because I know Oksana and Jess are waiting there patiently for me to crack on. Oksana, so as you know, as I mentioned, a lot of people are looking to leave the UK. For someone who's moving to the UAE, what advice would you give that family who are considering relocation to the UAE in 2026? And bear in mind, 2026 is critical because prior to the war, it was given answers to why they would move. Can you explain to us why they'll be looking to move now?
Thank you very much for your kind introduction. First of all, I would like to highlight that relocation should be approached as a full international structuring and not only lifestyle transition and not only simple tax move. The earlier planning start, the better the outcome usually will be. Families should think beyond the immediate tax saving and focus on long-term wealth preservation and succession planning, mobility, and quality of life. In the current situation, we can definitely see that UAE evolved more stronger. We have proved to the public that we can stand in any time, and it's quite safe even in recent situation. A successful relocation always combine immigration tax advice, structuring, banking, if the family has kids, education matter, choose right school, and of course families should always review their worldwide assets before moving to the UAE, and these assets should include UK property if any business ties with UK or home country, if they have any trust or investment portfolio outside the UAE. And of course, they always need to coordinate with UK and UAE advisors, because it's very critical from the beginning to decide and make right decision which jurisdiction to move and what would be their long-term plan. Because I believe after 5-10 years, it would not be so easy to move between the jurisdictions as we can do it now.
Thank you, Oksana. So we know from a UK perspective that a lot of clients are shifting and they are looking at alternative jurisdictions. So what you're saying about the UAE isn't just relevant for a client moving from the UK, it could be from anywhere in the world.
Yeah.
So that's really helpful. Jess, you've got the hard part here because we're trying to keep people in the UK, but sadly, you know, most of them are looking to go. So apart from our lovely, horrible weather, what are the main push factors driving people out of the UK? And from your client base and the experience you've had with clients coming to you, are you seeing a lot of movement from the UK to the UAE at the moment?
Thanks. So I'd probably say, as Oksana mentioned, actually quality of life is one of the reasons which is driving people to consider the UAE. But also, I'd probably say the sort of number one or main push factor is actually the fact that there's no personal taxation, and it seems to be the one issue in the UK that individuals are struggling with. So, you know, if you've got a business owner and they move out to the UAE, dividends can be paid out of that UK business with no UK tax implications. And so that, you know, versus actually remaining in the UK and paying 45%. So that's a massive push factor. And then generally, obviously, for employment reasons, I've seen business and investment opportunities out in the UAE. So all of that is driving clients to move out there. And we've certainly seen a huge number of clients going out there. And I wouldn't even say the political climate has necessarily halted that. It's just made people rethink timing of departure from the UK, but the plan still remains to leave.
Yeah, I think within my client base, I definitely noticed a pause, but it was never a no to say we're definitely going out there. It was more about, as you say, the timing. So just to stay on with you, we have a lot of taxes, as most people know, in the UK. So from a UK tax perspective, what are the most critical decisions clients need to make before departure? So if you wouldn't mind elaborating on the concept of residency and how people could cease to become UK tax resident if they are looking to leave, which is really important.
So I guess number one is the one principal things that clients need to think about is how they actually become non-UK tax resident by reference to our statutory residence test. And I guess before we even get into that, the conversation that we need to be having with clients, you know, when do you plan to move to the UAE? Some clients are flexible, others have a specific date in mind, or taking into account when kids start school, etc., or for employment reasons. Then we're looking at what ties will you retain to the UK. So are you planning, so is a client planning to leave and move to the UAE, but the wife and minor children remain in the UK, or is the whole family leaving? Are you going to retain a home in the UK, or do you plan to let out the home that you have now? Do you plan to return to the UK for work? What business interests will you maintain, or what roles will you keep within a UK business? And that's sort of, you know, are you going to continue acting as a director or a key decision maker? Once we've looked at all those sort of understood those plans, then we need to work out, well, how do you become non-UK tax resident, and looking at our statutory residence test. And it's not the most straightforward, but mainly when somebody's leaving the UK, we're looking at, well, are you moving to work full-time abroad? Are you maintaining your UK home? Do you have a home in the UAE? Have you established that home? If not, we're looking at advising on how you establish a home in the UAE, and that's quite important because that will impact the timing of your departure from the UK and being non-UK tax resident within the tax year. What ties will we have to the UK? That's going to be really important because that's going to determine how many days you can spend in the UK within a tax year going forward without becoming tax resident in the UK. So that's looking at, you know, is your spouse to be UK tax? You're planning to work in the UK? We need to look at if you're going to have accommodation in the UK that's available to you. So those are the sort of ties that we're looking at. And then from there, we need to be looking at the timing of departure. So ideally, from a UK tax perspective, a client's leaving at the start of the UK tax year, so in and around the 6th of April. So either shortly after 6th of April or ideally even before 6th of April. If, however, somebody is looking to leave the UK partway through a tax year, so for example, let's say leaving in August, then we need to look at split year treatment, which from a UK tax perspective, that means looking at splitting the UK tax year into two parts. One part where you're UK tax resident, and the other part where you've essentially started your non-UK tax residence and you're taxed as a non-UK tax resident. The important thing is if you can't get split year treatment, so there's certain cases that a client has to qualify under. If you're unable to get split year treatment, then you're effectively tax resident for the whole tax year. So you might be tax resident for the whole year, even if you leave the UK, let's say in August. And in that case, then we're looking at the double tax treaty and assessing what country has taxing rights under the double tax treaty, where income and gains need to be paid. So that's also one of the points that's quite important. It's that timing of departure and when you are treated as being non-UK tax resident. And then lastly, I'd say timing of disposal of assets or any reorganization. You know, we need to consider when that should occur, usually when you're non-UK tax resident, which sort of brings you back to making sure that you're able to qualify as non-UK tax resident. So I would say these are sort of the key things that need to be considered.
Thank you, Jess. So I think you've touched on some really key points there. So seizing UK tax residency is really important, and that is for income tax and capital gains tax purposes. However, the biggest question I get from my clients is normally around inheritance tax, because the rate of inheritance tax is 40% in the UK. You've got some allowances, £325,000, but that's quite a small allowance, especially if you own a property in London. It's a nightmare. So you are going to be within the scope of inheritance tax. Can you just explain to the listeners about how an individual ceases to be within the scope of UK inheritance tax? Because I think it's often these rules that confuse individuals quite a lot. They think that once they're physically out, that's it, there is no inheritance tax. If you wouldn't mind, in a couple of sentences, just elaborating on what that means.
Yep. So you're right in the sense that people leave the UK and then think they're outside of the scope of UK inheritance tax. If you have been UK tax resident for more than 10 years and up to more than 20 years, essentially you will have what we call an inheritance tax tail of between 3 years and 10 years. What this means is the inheritance tax tail is effectively the period of time in which you remain within the scope of UK inheritance tax on your worldwide assets. So it essentially goes from 10 to 13 years of UK residence. You start at a 3-year IHT tail. So for 3 years of non-UK residents, you are subject to UK inheritance tax on your worldwide assets. So what this means is you need to, and if you've been UK resident for 20 plus years, then you're subject to a 10-year inheritance tax tail. So it's a long time. So what you need to be monitoring and careful with is that you are actually non-UK tax resident and remain non-UK tax resident. So eventually you lose that tail. Once you have surpassed that sort of period of time, your IHT tail, only your UK assets will be subject to inheritance tax. Anything outside the UK will not be subject to inheritance tax. And that's something that clients really need to be mindful of, particularly with any structuring they're doing outside the UK, which might have an inheritance tax impact.
Thank you, Jess. That's really helpful. So again, remember, capital gains tax, income tax, determined by residency, and so is inheritance tax from now on. So the statutory residence test has to be a bedtime reading for everyone if they are looking to leave the UK. So Oksana, coming back to you, so the individual in my head has left the UK. They've taken Jess's advice. They've neatly decided when to go to the UAE. Let's now talk about the tax positioning for these individuals on arrival in the UAE. So once this family decides to go to the UAE, what does getting it right from day one look like? Can you talk us through some of the residency options, the visa options, etc.? Thank you.
Proper implementation from day one significantly reduce future tax and banking and compliance risk. And in first place, I would recommend client to make a proper plan, because families should establish genuine residency immediately rather than maintaining half in, half out arrangement. Because we see sometimes cases people are thinking, I don't need visa to the UAE, I can travel on tourist visa, is not appropriate and right thing to do. So the key objective for credible relocation is study from both practical and tax sides and perspective. The first step to determine right residency visa, to be able to get residency ID, relocate physically for the main sponsor of the family, and then sponsor the family, lease apartment or purchase property, open local bank account, enroll kids to school in the UAE. And there are several visa types which are available in the UAE. Overall, UAE is well known for very friendly family immigration policies. And for high net worth individuals and entrepreneurs, there are few types of golden visas available, which are valid for 10 years. They can buy property in the UAE with the value of 2 million dirham. Even this property can be mortgaged and they will be still qualified to obtain 10 years visa, or they can place fixed deposit with the local bank and also get 10 years visa. And the funds will be released after 2 years, and they can spend buying property or business or whatever they decide. Another route for normal people working in ordinary companies, they can be employed, they can find job, they can obtain employment visa, they can be sponsored by the company and sponsor their family members. Also, there is another category of skilled professional golden visa, which will give them also opportunity to have 10 years residency. And even if they change their jobs or leave the UAE, their visa will remain active. And of course, for their family members as well. Also, for entrepreneurs, there is another option, setting up a company. They can set up a company in the UAE and they can have partner visa as owner of the company, which is quite popular. And for some people, sometimes another solution to touch the water is to apply for freelancer visa, which is very smooth, easy process. Of course, it doesn't give any substance, but it's good start. No need to have employment with a local company or establish company locally in the UAE. And for those who are working remotely in any country in the world, they can also apply for remote working visa, which will give them nomad status and they can work digitally in the UAE. And the visa will be valid around 1 year. These are the main categories for visas, but it's very important to highlight that having residency visa will not change tax status, because in the UAE, residency visa is only the right to live in the UAE, but to obtain the residency certificate, person should spend some time in the UAE, and the authorities are very strict here. They would ask for immigration report, and the client has to prove that he's been in the country more than 90 days for domestic certificate, and for international double taxation treaty certificate, normally they have to stay in the UAE over 183 days. They need to lease locally apartment, and they need to have a bank account with a local bank.
Okay, thank you, Oksana. It looks as though there are a number of options for clients looking to move to the UAE, which is not much that we can say from the UK perspective. So it sounds as though the UAE is very welcoming. And you also mentioned making sure that you're keeping an eye on the evidence. So record keeping becomes really important. And that's something I think that we share with in the UK, that whenever you're looking at your residency position, record keeping is so important, because if you are questioned by HMRC about residency, you've got to do the same to prove that either you were or weren't in the UK. So a lot of us have heard a lot of horror relocation stories and the common mistakes that clients make. So I'm just going to ask you, Jess, because I know you've had a couple of clients in the past where they haven't taken advice and the relocation has gone wrong. Do you want to just explain some of the common mistakes that individuals make when they do head over to the UAE without taking much planning steps?
Yeah, so I guess you and Oksana actually touched on one of the points, which is poor record keeping. So sort of relying on sort of very rough estimates of time spent in the UK, rather than having a sort of good track or good record of the days actually spent in the UK and spent in other jurisdictions. So keeping records of flights, boarding passes, good records of where you've actually spent time, when you've actually come to the UK, specifically with the dates and the times when you've left the UK. This is really important, not only if you had a HMRC inquiry, but just generally so that you are able to keep on top of how much time you've spent in the UK and always allowing yourself a little bit of a buffer if there's an emergency which requires you to come back to the UK. You've kept a few days to allow yourself to do that. And one of the key things I always see with this is actually not counting days accurately. So not realizing that a day in the UK is a day in which you're here at midnight. And then also one thing to note, and I did say it's not just counting how many days you spend in the UK, but also where else you're spending time. And the reason I say this is because one of the ties under our residence test, one of the ties is called a country tie, and it only applies to people who have left the UK. And essentially what it means is you need to spend more time in another jurisdiction as compared to the UK. So one of the key things to do is to make sure that you have the amount of days that you can spend in the UK and you're tracking that, but also that you can show that you have spent more time in, let's say, the UAE as compared to the UK. But I'm aware that a lot of clients might travel for business, so you just want to make sure that the UK is not where you have spent the most number of days within the tax year. And then I guess another point which sort of ties in with the record keeping and what I've just mentioned is just generally failing to understand how our statutory residence test works. You don't qualify as non-UK tax resident if you spend less than 6 months in the UK. It's more nuanced than that, our residence test. You might be quite restricted in the number of days you can spend in the UK, so you might even be restricted to 45 days or 90 days. It all depends on how many ties you keep in the UK. Are you working in the UK? How many days are you working in the UK? What counts as a working day? A day counts as a working day if you're working 3 hours or more on a particular day. you know, is your spouse or your common partner, are they UK tax resident? Do you have minor children who are UK tax resident? All these things have to be looked at, and there's nuances to all the parts of our statutory residence test that need to be looked at, and often people might have a gist of how residence works but don't understand the sort of technical points, and that's where really advice is quite important. And then something again that we mentioned earlier, which is just generally not understanding IHT exposure, and understanding that, okay, you've left the UK but you're actually still exposed to inheritance tax for a number of years, and again that requires you looking at how long you've spent in the UK to work out how long you remain subject to UK inheritance tax when you are non-UK resident. And the reason that's important is that it might impact some of the structuring that you're doing. So if you're still subject to UK inheritance tax, you have to be really, really careful with setting up trusts or any structures that are akin to a trust structure. So that's one of the things that clients just really need to be wary of.
Thanks, Jess. Remember this 90-day myth. The number of times I get asked questions by clients to say, oh yeah, I only did 90 days, so I'm fine. I'm like, no, there's a test there, but you could spend less than 90 days and still be caught in the UK. So that was really helpful. Jess, you touched on structuring and making sure that you take the necessary steps to ensure that you're nicely out of the UK. When entering the UAE, Oksana, when clients ask about structuring, often they've said to me that they hear very different answers from UAE advisors. Do you want to break that misconception and tell us how you would approach structuring so it works from a UAE perspective?
Yes, it's correct. And we always say our clients, the structures should always begin with the cross-border objectives rather than focusing only on UAE tax advantages. It's true, there are no income tax, there is no capital gain tax, there is no inheritance tax in the UAE. It's correct, but there is no universal structure that works for everyone in the UAE. We begin with family objectives. Normally, we break them into few categories such as succession, governance, asset protection, and flexibility. How many months client is going to stay in the UAE, will be they living physically or not. Then always UAE structures should analyze alongside with the UK and international consequences. And the advice from UK is must. It's impossible to implement the structure without taking advice from the home country tax lawyer. The official UAE structure always may involve a few elements. We do not set up trust in the UAE because it is civil law jurisdiction. Normally, we would recommend clients setting up a foundation, and foundation is great for asset protection, also succession planning, because we have a lot of families which are Muslim, and overall in the UAE, the applicable law based on Sharia principles. And to avoid any future surprises and long probates, we always recommend client follow the instruments which work here locally. And honestly, it depends on the final goal of the client. If they want to have succession tool, or they just want to achieve maybe zero tax rate, setting up family foundation. Because in the UAE, foundation is treated as a company, as it has features of the company, and it must register for corporate tax. However, if the foundation is classified as a family foundation and it holds long-term investments, it's possible to apply for tax exemption, and client can benefit also from zero rate tax, which is very attractive.
Okay, that's again really helpful. So in the UK, as everyone knows, we're obsessed with trusts. Not so much anymore for tax reasons, but mostly for asset protection and succession planning for the next generation. So I think the concept of foundation comes up quite often. And whenever we have clients who are looking to relocate to the UAE, one of the first questions they ask us is, should I be setting up a foundation? Oksana, do you think that these UAE foundations are going to become a dominant holding structure for international families in the region?
Yes, and in the UAE, we also have a few options which we recommend our clients where they can register foundations, which are DIFC and IGGM under common law and RAC ICC in Emirate Ras Al Khaimah under local rules. But foundation is the most popular one because it gives a lot of flexibility. Client can amend charter and bylaws to achieve their goals. And we see more and more interest for people who are moving to the region to register foundation to hold their property portfolio of investments under foundation rather than under holding company. And this trend will increase in the future because, as I mentioned, there is a benefit with zero rate tax.
Yeah, and just you mentioned trend there. What trends do you expect to see over the next 5 years in the UAE? Do you think we'll still remain with foundations, or is there more?
The main trend, what we see, the migration of millionaires and high net worth individuals will continue despite the fact and conflict in the region because we are still extremely busy. There is no sign of slowdown in the region, and also a lot of families, they are already planning to transfer some assets which are now under trust structures in different jurisdictions under the UAE Foundation because it gives more flexibility. And in the recent 5 years, we see trend that clients start move their investment portfolios from such big financial centers as Monaco and Switzerland to the UAE due to international tensions. And the credibility of the UAE is still very high. And this will be a trend in the next 5-10 years.
Yeah. So from what you're saying there, Oksana, and correct me if I've misheard, so you're saying that we're seeing a shift away from the traditional offshore structures more towards a UAE holding structure, is that right?
Correct, because UAE is not just tax haven, the jurisdiction which has substance. It has low tax, which is 9%. It has substance and it has infrastructure. And people who are setting up structures in 70% of cases, they are really living in the UAE.
Okay. So the UAE, you mentioned the UAE corporate tax. Would you mind elaborating on that briefly? When do they apply and what the rates are?
UAE corporate tax is 9%, and every company must register for corporate tax within 3 months from the incorporation date to avoid 10,000 dirham fine. But for the foundation, it's possible to apply for exemption after submission annual return, and of course it's subject of approval by federal tax authorities. But if the foundation is registered as a family foundation and holds long-term investments, the chances are very high.
Okay, and just to bring Jess in, because you've sat there patiently, with the UK angle to the clients, Oksana mentioned, they come to the UAE, they set up these structures. What issues arise if, say, a UK person who's still got their tail to the UK, subject to inheritance tax, maybe for 3 years, 4, 5, 10, etc. What issues arise if they end up implementing a foundation without looking at both sides?
So I guess under UK law, the foundation doesn't exist as a sort of legal concept. So the thing that we're looking at here is how would HMRC treat the foundation, let's say, that we're looking at, the structure that we're looking at, and they'll look through that structure and they'll try and categorize it. So they'll be looking at whether is it a trust, is it a substantive trust that's been set up, is it a company, or is it akin to something like a nominee arrangement or a bare trust where effectively set law owns the assets, was treated as still retaining the assets in their estate. And what we don't, I guess, want to have is a situation where we've created a trust and you're still within the UK inheritance tax net. And that's because then we need to be looking at, well, is there an inheritance tax charge on you having created the trust? Are there going to be ongoing trust charges, and that could be and then afterwards, after you've actually lost your inheritance tax tail, there might be what we call sort of an exit charge on the trust assets, and so all of this, we want to avoid all of this essentially. So it's better to have set up something that's akin to a company or even a nominee arrangement to avoid these issues. And of course, the risk is that you have sort of created some sort of trust structure that's actually still subject to UK inheritance tax, and you can continue to benefit from that structure, which normally a settlor would, which means that there's a risk here that if you were to pass away while subject to inheritance tax, so in that IHT tail period, that the value of those assets would still be subject to inheritance tax on top of the fact that you have separate trust charges. So this is the kind of consequences that we're trying to avoid in making sure that we have a joined up approach in working together with so your UK advisors working together with your UAE advisor to make sure that the right structures put in place, and so that something like a trust isn't set up whilst you're still subject to UK inheritance tax.
Yeah, and also there are some clients might only go there for a short period of time, or life events might make you come back to the UK. So again, you've got to take into account these eventualities and make sure that whatever you're creating in either side of the jurisdiction is actually looked at properly to allow for those changes and events that could potentially come in and get you back to the UK. For example, we had obviously the war, and it meant clients came back. Then how do you navigate all of that? So really important to look at that. So let's now move on to the boring side, which is the compliance, which is what keeps everyone quite busy, both in the UAE and in the UK. Oksana, so what should families realistically expect around AML, CRS, FATCA, all these global transparency reporting requirements once they relocate and restructure in the UAE?
In the UAE, we follow OECD standards, and we also have CRS and FATCA, and foundations are subject of reporting requirements. And even though the jurisdiction for many years was considered a tax haven, but these days it's relatively complex process to open a local bank account, and the local regulators such as DIFC and IGGM, they are very strict with the source of funds. And during the onboarding of our clients, we go through a long process, anti-money laundering procedures to complete the onboarding process with a successful cases to register the company and structure, because there are cases when the applicants are rejected because the application was not prepared in the right way. So from our end, we follow all regulations from Ministry of Finance. And as you have seen recently in 2025, UAE was removed from gray list of OECD, and now we are a white rated jurisdiction.
Okay, thank you. And Jess, from a UK perspective, if I leave the UK and move to the UAE, is this the end of all my compliance, or has HMRC got news for me?
So it depends on what you sort of left behind, let's say. So reporting continues and compliance continues if let's say you've retained a UK property and you've decided to let it out, then you're going to continue to pay UK income tax on that rental income. So you'll still have to report that on an annual basis. Also, if you have any sort of UK source income, so let's say, for example, you continue to do work in the UK, you might have to still operate PAYE or complete a self-assessment tax return to report on that UK employment income. So having left the UK, you might still have reporting and compliance obligations. But it just depends on what, if any, income gains you have in the UK. And just generally to bear in mind that you know, it is self-assessment. So HMRC expects that you will sort of self-report, and whilst you don't have to, let's say, tell them that you have left the UK, it's always good to do a sort of last non-resident, do a last self-assessment tax return to sort of say to HMRC, I've become non-UK tax resident.
Thank you, Jess. I will never forget this letter from HMRC. I think their slogan is "Come to us before we come to you." So keep that in mind when it comes to self-assessment. That's really interesting. Just one point to add before we move on to Oksana's case study, where we bring all of everything that we've discussed to action. When you have relocated and you are in between different jurisdictions, UK, UAE, or wherever else you might hold assets, just think about your succession planning as well. So today we've covered taxes, but your succession planning is as important. As they say, two things in life are certain: death and taxes. So, you know, sadly, everyone's going to pass away at some point. So make sure that you have your planning in order, that you have a will in place, ideally looking at your UK situation, if you've left your assets here, and also in the UAE. I get asked a lot of questions from British expats who are non-Muslims going to the UAE as to whether Sharia might impact them. So all of that needs to be considered. And, you know, you've got the DIFC courts, you've got the local courts. Make life a bit simple and make it certain, and just do your estate planning, because it is a document that you can get quite easily from your advisors. So please don't forget that. A lot of people that end up going there becomes very obsessed with creating wealth and growing their assets, companies, etc. But then they forget what happens to their children if they pass away whilst they are in the UAE, what happens to their assets on death when they're between the two jurisdictions. So all of that is really important. And the concept of domicile, so I know we've talked a lot about residency, concept of domicile is still very much relevant when it comes to asset planning, succession planning, all your wills, etc. But enough of that. So I'm just going to go to the fun bit, which is Oksana's case study, where she will bring everything that we've discussed to life. So Oksana, can you walk us through a typical relocation case? I
Yes.
think we've got some slides.
So as you can see, we have one of the more typical case when relocation happened to the UAE from UK. There is a family. Normally there are 2-3 kids. They are moving to live physically in the UAE, and from the early stages they start to ask what kind of the best residency visa they can acquire. And we normally recommend for this type of client profile to apply for golden visa under property or fixed deposit. Fixed deposit might be the most efficient and fast one, because if they will apply under property, they wouldn't be able to sell the property. Otherwise, they have to cancel their residency visa. The moment they'll get their residency visa in the UAE, they are able to rent apartment and start the application for their family members and sponsor their families. And then the actual movement of wealth start. They start thinking buying property locally. And at this stage, we would recommend client setting up foundation. And the foundation can hold property directly, but for more sophisticated structures, we would recommend to have another SPV within the same free zone, which will hold, for example, Dubai Villa, or it can also hold portfolio of investments. And having this structure, they separate their legal ownership. The asset does not belong to them directly. Property belongs to foundation, and if the property will be leased long-term for commercial purpose, they can get exemption from the taxes. And also the assets under the foundation can be easily transferred in the future to their kids. So it's more efficient. Of course, they can also have a will, and maybe someone will ask, why would you recommend setting up foundation and increase the cost? But with the will, the process is different. With the will, they need to get a court probate to get the distribution of the assets in case if the owner will pass away. I think today it's one of the most popular structure when someone is moving to the UAE to protect the assets and structure wealth locally.
Thanks, Oksana. Yeah, classic on mute. So is this your typical client, and this is the typical structure that you would recommend to somebody moving, or could this be moved slightly if, say, circumstances are different?
Of
I'm just
course,
looking.
if the client is buying property and the value of client is lower, they can have only foundation holding the assets and portfolio of investments. There is no requirement to have additional level for SPV. This is just for ease of structuring. Sometimes, especially recently, we got a lot of cases when people are setting up foundation just to hold their portfolio of investments with interactive brokers or investment bank in Monaco or Switzerland. It's also very popular.
Okay, amazing. Jess, I'm going to bring you in, and I know you haven't had much chance to look at the question that's come in, but we've got a question, and given that Oksana's one of the objectives on her slide says exit UK tax residency efficiently, this question ties in nicely with that. So the question is, will you be covering tax efficient extraction of value from existing UK companies once someone is UAE resident, either by way of dividends from historic retained profits and salary, or management charges on future profits from UK trading and or investment companies? There's a lot in that question, so maybe a high level answer.
Yeah, and whoever's asked that, happy for you to contact us sort of afterwards to maybe discuss that in more detail. But effectively, if you are non-UK resident, and I guess this is the key point, you have to be comfortable that you're non-UK tax resident, you can extract dividends tax efficiently, so have a dividend paid from a UK company to a non-UK tax resident shareholder, and say if they are in the UAE, there will be no personal income tax on that dividend payment. So timing of extracting profits by way of dividend payments when you're non-UK resident is one of the key structuring points that we advise around. And then I guess in terms of salary, I think was part of that question. It all depends. Everything else depends on in terms of where work is being undertaken, where services are being provided. So we have to be careful in terms of where that's happening, and then working out whether it's subject to UK income tax or it's outside of scope because it's being carried out, let's say, in the UAE. So that's where you sort of need to really have a think and get specific advice in terms of profit extraction and the best way to manage being paid either salary or management fees, or whether dividends is sufficient.
Yeah, and then obviously corporation tax. So again, as part of the structuring with clients, we go through what would be most tax efficient with them. So for some people, they might just start afresh in the UAE with new companies, etc. But that's a really good question. So if you need more advice on that, the listener who's asked that question, then feel free to get in contact. I think keep your questions coming because I've only had one. I can't be asking all the questions. So come on, even if you...
There is actually a couple more.
Is there another one? Oh, okay.
Yeah, there is. So somebody was just asking, Oksana, you could maybe highlight again the benefits of a family foundation over a trust structure.
Yeah, sure. It depends, first of all, which assets will be transferred into the structure. And if the client has UAE or GCC linked assets, it's highly recommended to have UAE foundation. Actually, it could be both and foundation and trust. We saw those structures in the past. It's also very popular and depends on the client. But for those who has UAE or GCC assets, foundation is recommended because the UAE is civil law jurisdiction.
Amazing.
Okay,
I
great.
hope that answers the question. Bianca, do you want to read another person's questions? I'm not sure if everyone's can see them.
I'm not sure that everyone has access to read it, but this might require a little bit of input from both Jessica and Oksana. In terms of UK trust classification of a UAE foundation, would your team advise a client to draft the foundation and corporation documents, have it reviewed by the UK team first for wording that falls outside of a trust being created from a UK perspective?
We work very close with private clients, lawyers, and tax firms, but also Sovereign has an office in London, which was established in 1997, along with Dubai office in 1998. So we have a lot of experience, and if we see that the request from the clients is very sophisticated and complex, 100% we would recommend to engage tax lawyer or private client lawyer for appropriate drafting. That's why we have this webinar together, because we have a lot of these cases where we work together with lawyers, because Sovereign Group is a corporate service provider. We implement and administer the structure.
Yeah. And Jess, do you want to add anything from a UK perspective?
Just to sort of second what Oksana said, which is definitely we would work together as a team so we can look at the drafting and just make sure that there's nothing in the terms that make the structure akin to a sort of substantive trust. So everything's sort of a clean way of structuring the foundation, because we're both involved to make sure that everything's done properly and there's no sort of surprises later down the line, and just to minimize risk. I think that's the key thing with a lot of this planning and what we're saying to clients. It's minimizing the risk that something could go wrong in the future.
Yeah, and if you take the advice early before you've actually signed any documentation, you've got more options available to you and more opportunity to change any particular terms that then might become problematic later on. So don't leave it till after the events happen. Do it at the beginning where you've got many options open to you. We've got someone who's put their hand up. I can't see his name. Let me just Simon. Are we
Simon, if you wouldn't mind just typing out your questions so that we can get round to it. But in the meantime, Samuel was just asking about whether the conflict has impacted things here in Dubai. Oksana, maybe you could take that from like a client interest perspective.
As I mentioned before, we don't see a shift and lack of interest from the international clients to proceed with the structures in the UAE. In March, there was a slight delay with the actual relocation because there was not the same number of flights. But as you can see, schools are working as normal. Everyone who traveled initially out, they all are back. And we are busy as always, and even more because a lot of questions are coming from international clients who delay their decision. Now they want to proceed even faster, especially those who have some assets which are not yet structured. In case if something happened, they have already structure in place and everything is secure.
Yeah, great. I think that same message has been kind of reverberated throughout the team. I know that we had a record licensing month last month, which maybe you wouldn't expect. So that's quite interesting. I've got another question here from Angela about if the director works from the UAE solely, can the UK company get corporate tax deduction for salary paid to them?
I'm not a corporate tax lawyer, so I'm not necessarily going to be able to answer that. I would have assumed that it's an expense, so it's probably a deductible, but I can't really give you an answer to that because I do personal taxes, not corporate tax, I'm afraid.
No problem. Andrea's asked here, the UAE is a combined jurisdiction with DIFC and ADGM, specifically common law governed. Oh, okay, so she's just adding to the fact that DIFC and ADGM offer common law, which is obviously why it becomes appealing to international investors. Yes, absolutely true, Andrea. I think a couple more questions come through. What is the advantage of having an SPV structure in a UAE foundation setup, Oksana?
There are sometimes some cases, for example, with setting up account with interactive brokers and having holding company to hold portfolio of investments would be more efficient in terms of onboarding and opening a trading account. And in other cases, if there is a property, let's say outside the UAE, less likely it would be permitted in a foreign jurisdiction to hold that asset under UAE foundation. That's why we would recommend to have another holding company. The type will be SPV to hold that specific asset.
Yeah, great. Another question looped back towards the family foundations, because they are generally incorporated in ADGM and DIFC, which is common law. How does it differentiate from trust structure? Maybe the difference wasn't clear before.
In first place, foundation and trust are completely different tools. As you can see from this slide, first of all, foundation is legal entity, the same as a company, and trust is more formal fiduciary engagement, is relationship, yeah, in first place. So this is the key difference, because the nature of these tools is completely different. But the key similarity is, together with foundation and trust, you separate legal ownership from your asset from yourself, you transfer into foundation, or you transfer under trustee name.
So Simon's just put in here about, what about family investment company organized in the UAE for a UK person that is about to relocate?
It's possible to register an investment company for the family who is planning to relocate to the UAE, and there are a few types of these companies. You can register a holding company with investment in commercial enterprise activity to hold different class of assets, or you can have a family office. We have activity, single family office in the UAE, and with this activity you can manage family business, you can invest in different stocks and different businesses.
Yeah, so although we focused on foundations today, there are different avenues that it would depend on what best suits the client, right? Yeah, of course. So I think that's all the questions that I can see. Unless there's anything else, I'd just like to firstly thank the speakers. So Oksana, Jessica, Yousafa, thank you so much for your contributions today. As you can hear, there's a lot to consider if you're going to move from the UK. So plan early, and preparation, I think, is what it sounds like you need ahead of considering a move. Like Oksana mentioned, I think what's really nice between this partnership that we've set up here with Irwin Mitchell today is that we have so many touch points for clients that are, considering this process. We've got Irwin Mitchell that are in the UK. We've got actually Sovereign UK who have been there since 1997. So also another, corporate service trust point. And then you've got the team where Oksana and I are based here in our Dubai office, which has been open since 1998. Yeah, we hope that you guys found this session to be informative. And if you have any other questions, like the ladies have mentioned already, please reach out to them directly. Yeah, thank you very much, everybody, for your time, and enjoy the rest of your day. Thanks, guys. Bye.
Thank you. Bye.
Thank you.